Welcome back to SQE1, my dear future solicitors. We have reached the part of contract law that makes bankers smile and directors sweat. Guarantees and indemnities. That's a very interesting topic. We will try to just look at how they are important in our contract law learning. These are promises, both guarantees and indemnities are promises that support other contract, backup plans, safety nets, or as some might say in case of human failure, they are common in business, banking, and tenancy agreements. Now, don't confuse them. A guarantee and an indemnity are cousins, not twins. They sound alike, but they behave very differently when things go wrong. A guarantee is a secondary promise. If he does not pay, I will. An indemnity is a primary promise. Even if he never owed you anything, I'll still pay. So if you are ever asked to sign a guarantee and indemnity clause, remember that's not redundancy. That's double insurance for the creditor, and the creditors love it. What is the nature of guarantee? The guarantee is a collateral promise to answer for others' debt or default. There are always three parties: the creditor, who owed money; the principal debtor, who actually owes the money; the guarantor, the poor soul who promises to pay if the debtor fails. It is a secondary obligation, mean the guarantor duty depends on the debtor's liability. If the debt itself disappears, say because it is void, illegal, or paid, the guarantee usually collapses too. In Moschi case, the court confirmed this. The guarantor obligation survives only as long as the debtor's obligation does. In simple terms, a guarantee is like agreeing to babysit someone else's debt, but only while the debt is alive. That's it, not more than that. So it is dependent on the debt. Guarantee is dependent on the debt. So what are the formalities of guarantee? So that's crucial procedural point. Guarantee must be in writing. As we talked about it before, like transfer of land and guarantees, they must be in writing, and this is under Section 4 of the Statute of Fraud 1677, very old law. A contract of guarantee is unenforceable unless it is in writing and signed by the guarantor or their authorized agent. This rule was made in the 17th century, back when quills were cutting-edge technology, but it still bites today because it is enforceable. That said, courts have adopted to the time a written confirmation, even an email, may satisfy the requirement if it is clearly recorded that this is guarantee. But there is the clever bit. Indemnities are not caught by this rule. They can be oral or implied. So when in doubt, creditors often label an agreement as a guarantee and indemnity to make sure it sticks. What is the nature of indemnity? That's different. An indemnity is far more robust in its operation and far more dangerous for the promiser. Unlike a guarantee, it is a primary obligation, not the secondary one. The indemnifier promises to compensate the creditor for any loss, whether or not the debtor is at fault. In practice, this means the creditor can skip the debtor entirely and go straight to the indemnifier. Imagine a supplier refuses to sell goods to a new company unless the director personally promises, I will be responsible for all losses. That is indemnity, not a conditional guarantee. So in Yeoman, credit versus later or letter, an indemnity was upheld even though the underlying contract was unenforceable. The debtor's contract might fail, but the indemnity stands firm, like a stubborn British postman in a thunderstorm. Poor souls. So now, distinguish how to distinguish between them. In exam, they love this. How do you tell a guarantee from an indemnity? How you distinguish? So think of it this way. A guarantee is conditional. If he does not pay, I will. An indemnity is absolute. I will pay, full stop, that's it. What is the key difference? There is a difference in its nature. Guarantee is secondary, while indemnity is a primary obligation. In terms of parties, in guarantee, there are three parties. In indemnity, there are two. Liability depends on debtor in guarantee, and in indemnity, it is independent. Guarantee must be in writing. Indemnity can be unwritten. Discharged if debt is void. In term of guarantee, yes. But in term of indemnity, no. Still, you need to pay for it. In Guild and Co. versus Connard, there is a case from 1894. The indemnity survived even when the main contract failed. That is the practical point. Indemnities are the creditor's insurance against everything going wrong. So, right for the guarantors. What are the rights in that case when a guarantor actually pays the debt? They are not left helpless. The law gives them several rights, a sort of legal thank you for cleaning up someone else's mess, right of subrogation, to stand in creditor's shoe and recover from the debtor. Number two, right to indemnity, to be reimbursed by the debtor for what they paid. And also they got right to contribution, to demand fair sharing of co-guarantors, other people who have given guarantees. Right to securities as well, they got it. Like if the creditor held any security for the debt, the guarantor gains its benefit. So these rights restore fairness and prevent the creditor from being paid twice. It is a quiet moment of justice in a world of financial chaos. So once you are a guarantor, it does not mean you are punished by law. So discharge of guarantor, how to discharge it? Like a guarantor promise is interpreted strictly, like, it is not like that broader interpretation. If the deal between the creditor and debtor change without the guarantor's consent, the guarantor is discharged. Like if they change the deal, the guarantor has nothing to do with it. The leading case is Home versus Brunskill. The parties changed the tenancy agreement without telling the guarantor. The court held that the guarantor was released because he agreed to guarantee that contract, not a new one, like, that is amended. A guarantor may be discharged by payment or release of the debtor, misrepresentation or non-disclosure by creditor before the guarantee was signed, or completion of the guaranteed obligation. In all these three cases, guarantor is discharged. The principle is simple. Guarantor's consent is sacred. That's what the whole guarantee is based upon. Change the bargain and you lose the security. In terms of commercial context and in modern practice, guarantees and indemnities are everywhere. Banks use them for loans and overdrafts. Landlords use them in tenancy agreement. Construction contracts rely on them for performance security. Parent companies use them to support subsidiaries. Most documents now use a guarantee or indemnity clause, the famous belt and braces approach. Even if the guarantee fails, the indemnity stands. This dual structure ensures creditors can always recover, regardless of technicalities. So when drafting or signing one, read it carefully. It is not just a friendly promise, it is a legally loaded booby trap. So careful once you are acting as a guarantor. The next thing is, there are common tips and pitfalls that we need to take care and avoid at some point. Number one, always define both clearly. Guarantee is secondary, indemnity is primary. Mention statute of fraud if you have to, and that is from 17th century. Writing is must for guarantee. Geomean credit case that shows us indemnities survive even the main contract fails. Explain right of guarantor, subrogation, indemnity, contribution or security in order to get what they have paid for. Discuss discharge. You need to just discuss with yourself what is discharge. So, especially like when it is varied or changed or amended without consent of guarantor. Identify, like, in exam you will get clues like if he fails, I shall pay. It's a guarantee. I shall be responsible for all losses. That's indemnity. That's to just tell it in very short form. What are different pitfalls? Treating all promises and guarantees like, check if it is conditional. So don't treat all promises as guarantees. No, it's not. Forgetting the writing requirement for guarantees, ignoring the independent nature of indemnities, and overlooking the guarantor's right to recover once they pay. Like, it does not mean they are left with nothing. They are punished for giving guarantee. Skipping the commercial context, examiner like applied understanding, like how it works in commercial settings. And that, my friends, is the world of guarantees and indemnities, where promises multiply, risk shifts, and the creditors always sleep a little better. Remember, in law as in life, never say I guarantee unless you truly mean it, because the courts certainly will. So you should not write a guarantee for someone you can't recover your money that you will pay, or trust that you have given them. So thank you very much for today. Ta-da!